There are two ways of attracting criminal liability for an offense, either as a principal or as an accessory. A principal is someone who has met all the requirements of the offense, both criminal conduct and state of mind. Effectively, they are the person who committed the actual crime. An accessory is someone who assisted or brought about the offense by contributing to the commission of the crime in some way. It is important to note that an accessory who aids, abets, counsels, or procures the commission of an offense will be treated by the courts in the same way as a principal offender, and the potential sentence given to them will be the same. Aiding means giving help, support, or assistance, whereas abetting means inciting, instigating, or encouraging. Both involve the presence of the accessory at the scene of the crime. Counseling and procuring take place before the commission of the offense rather than at the scene. Specifically, counseling means advising or instructing, and procuring means bringing about. Accessories who are present at the scene of a crime when it's committed may amount to encouragement sufficient to make them liable as aiders and abettors. Just being there at the time can be seen as giving support to the principal, but only if they are there as part of an agreement of the offense taking place. A member of the public who simply stands and watches an offense taking place without saying or doing anything is not liable as an aider or abettor. The general public are not under any legal duty to prevent an offense occurring, so standing by and doing nothing will not make them liable. However, it is important to mention that whilst failing to do anything to stop a crime is not enough for liability, if an accessory has some responsibility and the ability to control the actions of the principal, then his failure may attract liability, such as where a driving instructor fails to prevent a learner from driving without due care and attention. With regard to counseling and procuring, which take place away from the scene of the crime, case law states that counseling an offense requires no causal link. If the principal offender is aware of the counselor's advice or encouragement, the counselor will be liable as an accessory, even if the principal aimed to commit the offense without any encouragement. Procuring, however, requires a causal link, as it must be proven that the offense would not have taken place but for the procurement. Bear in mind that to be charged or convicted as an accessory, it isn't necessary for the principal to also be charged and convicted. It is possible for an accessory to be found guilty where the principal is acquitted, for example, where the principal has a defense or a mental health issue affecting his responsibility, but the accessory doesn't. Although the accessory is part of the principal's overall crime, their criminal liability is completely independent from the principal's.